fair.
Good afternoon, and may it please the court. My name is Steve Zansberg, bar number 26634, and I represent the appellee Ion Media Networks. With me at council table is Rachel Johnson, bar number 43597, who also appears on the brief, and she's with the Reporters Committee for Freedom of the Press. In 2020, Colorado's General Assembly responded to the murder of George Floyd and Eric Gardner and the death at the hands of police of Elijah McClain by enacting landmark legislation, which opposing counsel not only misunderstands but also misidentified as the body-worn camera footage. In fact, it has a title, and it is the Enhanced Law Enforcement Integrity Act. And it received national attention because it really was landmark legislation to very much increase accountability and transparency of police conduct, whether that conduct was appropriate or otherwise. And it mandates in the body-worn camera provision that all unedited video and audio recordings, that's a quote, from body-worn cameras, if a complaint, it mandates the public release of, quote, all unedited audio and video recordings from body-worn camera if a complaint has been filed regarding police conduct, and that footage must be released within 21 days of the agency receiving a request from any member of the public. Here, that request was received on September 26, 2023 by Lakewood Police Department.
Counsel, you're not taking issue or exception to the blurring of the face and the head, are you?
We have not cross-appealed that issue, that's correct.
Thank you.
But the district court did not err when it ruled first in May of 24 and then in July of that year on reconsideration that the statute requires Lakewood Police to provide the requester with, quote, all unedited video and audio, as the statute says. And fundamentally, Lakewood Police did not meet its burden to establish that there was any substantial privacy interests involved in this footage. And if the complaint, if Mr. Freeman's correct that the judge didn't make a finding that there was substantial privacy interests at stake, then there's no basis for blurring. He assumes that, therefore, there wasn't a sufficient finding that blurring was sufficient. But if there wasn't an actual finding of privacy, and in fact, there is none here, then blurring is not authorized by the statute. As I said, we're not cross-appealing that portion of the judge's ruling. But with respect to, let me address a couple of the issues that were raised. First about the Children's Code. I'll dispense with that fairly quickly because there is no issue before the court that has been raised as to the appropriateness of the district court's ruling that the Children's Code expressly authorizes a judge to override Section 19-1-304 sub 2 sub A, which has been referenced here and in the briefs, but not subsection 7 of that, which the judge specifically referenced in the hearing transcript and in her order denying the motion for reconsideration, saying there is an exception. The court is authorized on court order to release any juvenile records. So even if these were juvenile delinquency records, which we don't concede, nothing prohibits the court from implementing a later acted, extremely specific statute dealing with these records and ordering their release. And that finding has not even been appealed. That provision of the Children's Code is nowhere mentioned in either of the two briefs and has not been mentioned by counsel. So there is no issue as to the effect of the Children's Code on the release of these recordings, which, as I said, we don't believe actually are juvenile delinquency records or even juvenile records. The legislature certainly knew how to preclude public release of certain records, including juvenile delinquency records or other juvenile records, when it enacted the Enhanced Law Enforcement Integrity Act.
Wait, can I just... Okay, but they're not trying, I know I'm not
fighting with you because I see where you're coming from, but they're not trying to preclude these, even if they are records, they're not trying to preclude them from being released if blurring is sufficient. Isn't that right? Under subsection 2A. So you look and see, is any part of this covered by subsection 2A? If yes, you release, but you blur.
That's correct. This statute is in complete harmony with the Children's Code. It makes reference to the Children's Code and makes clear that if there are privacy interests as recognized by the Children's Code or any other substantial privacy interest, then the video shall be released in a blurred fashion.
Okay, and then going back to your argument that there is no privacy interest at issue here, it seems like the legislature has determined that there are certain privacy interests that need to be accounted for. And one is we don't want to release identifying information about minors. That's why you have to blur the face so they're not identifiable. Why you disagree with that? You say no, subsection 2A, we can skip right over that in this case.
No, I think that subsection 2A provides for the allowance of a judge to order the release of juvenile records even if they are identifying. And the other portion of the Children's Code says that any minor who is charged with a crime involving a firearm or any felony of a certain measure as this would, is to be identified in publicly released criminal justice records. There is no exception for the identity of Ms. Martinez, who wielded a weapon and was accused of armed robbery, federal felony against the U.S. Postal Service. So her identity would not be maintained as confidential had there been
Mr. Zandberg, let me stop you just for a minute because I want to make sure that the record's clear on this. She was never accused in a formal sense. She was suspected of having committed that felony, and you agree that no criminal charges were ever filed, so there was no formal accusation.
Right.
Okay.
And there was a criminal proceeding against another individual involved, and those records have been released to the public, as well as the interviews from the internal affairs investigation, in which her hair color is identified as pink, which is why the judge said, I'm not going to allow her head to be seen.
Because the concept is you're trying not to identify the person, right?
Yes.
Okay, but in the statute, the juvenile records are including, okay? So minor stands alone. If the video depicts a minor, now we have an issue. It's including any information that might undermine the requirement to keep certain juvenile records confidential.
Right.
It's an including. But the minor alone triggers the privacy interest that requires the blurring so that you can't identify the minor.
Actually, that's, with all due respect, Your Honor, minors are not entitled to a right of privacy any greater than an adult.
But
it's
unless
true
the
that
legislature says so, they said so.
No, they said that minors are among the individuals who may have a substantial privacy interest. They named 5 categories of people who are subject to possible substantial privacy interests. They are, number 1, criminal defendants, number 2, victims, number 3, witnesses, number 4, juveniles, and number 5, informants. Any of those individuals depicted in the body-worn camera may have a substantial privacy interest. It doesn't mean they do. A criminal defendant doesn't necessarily, and in fact, none of those individuals retain a privacy interest after they are dead. There is no privacy rights. And by the way, this was acknowledged
before spending any time on that, you haven't cross-appealed the trial court's, the district court's determination that there was a privacy interest.
That's true, we haven't.
So let's not spend time.
The question is, don't minors automatically? The argument below is that, and I'll quote what Mr. Freeman said in the trial court at page 15, lines 6 through 7. Ms. Martinez, quote, is a minor, and therefore her status as a minor puts us into a situation where we felt that blurring was insufficient. Lakewood Police Department wants this court to find, as Your Honor said, that any time a minor is depicted on any body-worn camera footage, whether ends up being a decedent or otherwise, any of those 5 categories, any minor captured on a body-worn camera footage puts us in the category where blurring is insufficient.
Well, I heard counsel's argument to be a little bit more narrow. It was any death associated with a minor, that is an area where blurring is inherently insufficient. So that's the argument I heard. Why is, in your mind...
Wasn't the argument made below, Your Honor?
Why, in your opinion, is blurring sufficient in this case to protect the privacy interests at issue?
Well, the reason we believe blurring is sufficient is because, in truth, this minor, 17-year-old Mariana Martinez is not a victim of crime. And the statute only provides for notification of next of kin and allowing them to review footage when it is in association with a victim of crime. The only victim of crime in this incident was a U.S. Postal Service carrier named Fitzsimmons, William Fitzsimmons. He's not even in the video. So Ms. Martinez's privacy rights, to the extent she had any, standing out on an open street wielding a weapon, and whether she's 40 years old or 17 years old, she has no privacy rights with respect to that. It expired with her...
Mr. Zandberg,
yeah.
The predicate of the question is the trial court has determined that she has a privacy interest. You have not cross-appealed that.
That's correct.
So I want you to focus on the question I'm asking, which is why is blurring sufficient in your mind? Or stated another way, why do you disagree with the contention that blurring was insufficient?
We're not contending that it was insufficient. We simply have not cross-appealed on the ruling that blurring is sufficient.
Your counsel is arguing that it wasn't sufficient, and we should reverse this decision because blurring wasn't sufficient for the reasons you've already heard. Why do you disagree with that?
Because he hasn't made any showing that blurring is insufficient. So to the extent that there is a cognizable privacy interest in the identity of a 17-year-old gun-wielding assumed juvenile delinquent whose name would be disclosed had she been charged and survived, we believe that anonymizing the footage is sufficient. We're not contesting that. We just don't believe that. With respect to, let me focus on counsel's argument that 902B2 creates a right of next of kin of any victim of police shooting to veto to override the statute and prohibit the disclosure in its entirety of that video footage. 902B2B, if blurring is insufficient to protect the substantial privacy interests, follows the case law that only living individuals have a privacy interest. And that's clear from the second sentence. The only people who have the right to waive any privacy right with respect to footage that is insufficient, blurring is insufficient, are the persons themselves. There's no mention of next of kin in that provision. Why? Because next of kin cannot waive the privacy rights of a decedent family member. There is no privacy right in a decedent. And it's not, so the only people who have the right to waive and to allow release of unredacted or unblurred footage under 2B2 is the person whose substantial privacy rights, not their next of kin, unlike the victim's privacy, the victim's rights amendments that are, by the way, in SB 2017, that statute also on page 19 in sections 11 and 12 amended the victim's rights amendment 3 times with express reference to the statute. This bill affords next of kin of victims of crime certain rights to be notified and to review materials as the victim's rights statute amended in the same bill declares. It does not provide any rights to a crime victim, here none, but a crime victim's family members have the right to release unblurred footage. That's the sum total of the rights they have with respect to release to the public of footage. They have no right to veto the complete release of footage from the public, whether blurred or unblurred. And here, there are no victims of crime involved. So all of that is by way of confusion and mistake in reading the statute. That is really quite clear. We would conclude by saying that the district court's ruling should be affirmed, and the Lakewood police should be directed by this court forthwith to comply with the Enhanced Law Enforcement Integrity Act for a request that was made almost 2 years ago. Thank you.
Thank you. The court thanks both counsel, or all counsel, for your fine arguments and also for your briefing. The case is deemed submitted, and you may expect a written opinion in due course.